right, Judge, we are on the record in State versus Jacquell BUFFORD. He is present by video with his attorney, Mr. Lewis. We've got two charges, 20W05582, burglary in the first degree, and warrant number 20W05583, criminal damage to property in the second degree. Officer Edwards is present, and I'm also told that our victim, Mr. Thomas, may be listening in. Judge, may I swear on our witness?
Amen.
Officer Edwards, could you please raise your right hand? Do you solemnly swear or affirm that the testimony you shall give will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Please lower your hand and state your name.
Officer Jacquell Edwards with the Gwinnett County Police Department.
How long have you been with the Gwinnett County Police Department?
2 years.
Are you post-certified?
I am.
And did you take out the warrants in this case?
I did.
What led you to take out warrants?
So I've been investigating this address, 5089 Victor Trail, for roughly a month. I got information from one of the neighbors that the house was supposed to be unoccupied, and she had seen some males in their late teens and early 20s break into the house and going into the house and whatnot. Ultimately, through the investigation, we were able to identify the suspect vehicle as a black Nissan Altima with red wheels. I think it was April 15th, Mr. Thomas. He owns the house. I had spoken with him, and the house was unoccupied. He rents it out. He lives in Florida. It's a rental property for him. It had been unoccupied since about February. And he said no one was supposed to be in there, and he was willing to prosecute anybody that's, going inside the house. On April 15th, he returned from Florida and went into the house and found it had been just destroyed. He filed a report at that time, which is a separate report than this one. And at that time, he resecured the house. He added extra locks, nailed some of the doors shut, and stuff like that. I think it was April 17th. I don't remember the exact date. I responded there. Neighbors called and said they saw that same black Nissan, and I went around and checked the house. It was still secure at that time. On April 18th, I was able to locate the suspect vehicle off of Park Road, and I made contact with the occupants at that time, and one of them was one of the suspects in this case. I was able to interview him then, and he basically said he knew the house. He didn't know the exact address. He was able to kind of give me directions to it. He said that he and some of his friends would go there to smoke marijuana. But other than that, he wouldn't provide me with much information. He wouldn't provide me with information about any of the other suspects or anything like that.
Okay, I'm gonna have you pause right there. When you said that there was an occupant of the vehicle and you interviewed him, was that this defendant or somewhere else?
No, it was not. It was one of the other suspects in this case. It was Mr. Mendoza.
Okay. So what is the link to this defendant?
So on April 19th, neighbors called again and said they saw 2 Hispanic males and 2 black males break in the back door and go inside the house again. When we arrived at the location, we could see them looking at us through the windows and whatnot. Ultimately, we surrounded the house and called them out, and we took all 4 of them into custody. One of them was Mr. Bufford.
Okay. And do you see Mr. Bufford anywhere?
Yes, I do.
Can you identify him by something he's wearing?
Yes, he's in the green jumpsuit in the Zoom call.
Okay. Let the record reflect Officer Edwards has identified the defendant. What county did this take place in?
Gwinnett County.
All right. Anything else to add, Officer Edwards?
No, ma'am.
Approximate amount of damage. Could you determine whether or not it was $500 or more?
I approximated it to be at least $5,000 worth of damage. They had spray painted graffiti, and the carpet was destroyed. Multiple doors inside of the residence had been knocked off the hinges. There was holes in a whole bunch of walls from where they had just kicked holes in the walls and stuff. I don't have an exact number because I don't think Mr. Thomas has had anybody go and look at it yet and see exactly how much it's going to cost. But Just from a rough estimate, I said approximately $5,000.
Okay. All right, thank you. Those are all the questions I have for Officer Edwards.
Good afternoon, Officer Edwards. Can you hear me?
Yes, sir, I can hear you.
Okay, good. I'm going to try to talk slow since my client is right next to me. Okay, let me start here. Here we go. When you and the other officers surrounded the house, 4 individuals came out the house, correct?
Yeah, well, we didn't call them out of the house. We called them into the room that the back door leads into, the room that had been, or the door that had been forced open, and then we took them into custody inside that room.
You took
Yeah,
4
they
people
came down upstairs and into that room that we had contact with.
You took 4 people into custody, correct?
Yes, sir.
Did my client make a statement about damage to the property?
No, sir, he did not.
Okay, did any of the other 3 make any statements as to damage to the property?
No, sir, they did not.
Did my client tell you that he had been in the property prior to April 19th, 2020?
No, sir.
Okay, so you first spoke to the victim on April the 15th of 2020, correct?
Yes, sir.
Okay, you responded on April 17th, 2020 to the home, is that right?
I believe that was the date.
Okay, were you able to go inside the home and see the damage in the home at that time?
No, sir.
Okay, so see, what I'm trying to figure out is on April 19th, 2020, what was the difference in the damage between April 19th, 2020 and April 17th, 2020? Do you know?
No, sir, I do not.
Okay.
April 19th was the first time I had been inside of the home.
Okay, but the property owner, the victim, had already told you on April 15th, 2020 that the property had been damaged, is that right?
Correct.
Okay, and if I understand you correctly, my client never made any statement saying that he had been in the property prior to April 19th, 2020, correct?
Correct.
Okay. No, none of the neighbors said that they saw him in the property prior to April 2020, correct?
They had stated they had seen multiple males, Black and Hispanic males, going in and out of the house. They couldn't specifically identify any individuals, but
Okay, did they ever say they saw anybody removing anything from the property?
no, sir.
Okay, and Mr. Mendoza told you that when he went into the property solely for the purpose of smoking marijuana, is that right?
That is what he claimed. But his vehicle was the vehicle that the neighbors consistently saw there, and that was the only vehicle that they were able to identify as the suspect's vehicle.
Okay, and I understood that. My question is, nobody at any point in time saw anybody removing any sink or copper or ceiling fans or anything, is that right?
Not to my knowledge.
Okay, and so to the best of your knowledge, in terms of the people that had been inside the house, they indicated that they were only in the house to smoke marijuana, is that right?
That's what they claimed.
Okay. Do you have anything that would indicate anything else?
No, sir.
Okay.
Judge, I do have a brief redirect. The break-in in the back door, can you describe the damage, if any, to the back door on the 19th?
Ms. Henderson, just a moment. I don't know if Mr. Lewis said
That's
he was
fine,
finished.
that's fine.
He
You can
wasn't-
ask a question.
Okay, I don't think he was finished. He was still talking.
No, that's fine. She can ask a question.
Okay.
Oh, I'm sorry, Judge, I thought he was done.
Yeah, he didn't say he was.
That's fine, go ahead. She can ask a question.
Go ahead.
Okay. Officer, can you describe the back door? You said it had been broken into?
Correct. So Mr. Thomas had told me that he had a locksmith come and fix the locks, and then he also nailed the door shut himself. And the door frame was broken from where it had been kicked in and where it had been nailed, and then it broke the frame when they kicked it.
Do you have any basis for an opinion for how much that damage may have been?
I do not. I mean, as much as it would cost to replace a door and a frame.
In your training and experience, would that be more or less than $500?
Judge, I want to check. I don't know that he has any special training and experience as a law enforcement officer on construction costs.
That objection will be sustained.
Anything else you can tell us about the back break-in of the door?
No.
Okay, thank you, Judge.
Officer, when you entered the house on April April 19th, 2020, was there an odor of marijuana in the air?
Yes, there was.
Okay. Did you see any sort of alcohol being consumed? Did you see any alcohol bottles or cans or anything like that?
No, I did not.
Did anybody of the four, in your opinion, did anybody appear to be under the influence?
Not from what I could tell, no.
Okay. All right. Did you find any drugs or drug paraphernalia?
Yeah, we found some marijuana inside the house.
Okay. I don't have any further questions, Judge.
Any follow-up, Ms. Henderson?
No, Your Honor.
Any objection to this officer being excused?
I
No.
don't have objection, Judge.
Thank you, Officer Edwards.
Thank you.
Be excused. Ms. Henderson, any additional witnesses?
No, Judge.
Mr. Lewis?
Judge, I don't have any evidence. I only have argument.
Okay, go ahead.
Judge, respectfully, the burglary, 20W05582 should just be dismissed. Number one, we don't have any testimony about the damage to the property prior to April 19th, 2020. It's not an abandoned home. It's an empty home that the neighborhood boys or just outside the neighborhood boys have discovered that they can go there and smoke in privacy. That's what it is. So we don't have any information that my client was in that property prior to April 19, 2020. We don't have any information that the damage to the property as of April 19, 2020 is greater than $500 or there was any damage. The information that the officer received from an occupant that was stopped in the car somewhere around April 17, 2020 was, we smoke in the house. That's exactly what they found on April 19, 2020. So if you enter the house to smoke marijuana, that's not a burglary. You have to enter the house in Georgia. I don't know about Texas. In Georgia, you have to enter the house with the purpose of committing a felony. Smoking marijuana is not a felony. Or a theft. Theft of what? Theft of secrecy? There's no theft. Nobody's removing anything from the property. So ultimately, the burglary charge has to go away. We moved into the second charge, which is criminal damage to property in the second degree. We don't have any amount. We think we know what's damaged. We think that assume that it's true that the four broke in through the secure door. We don't have any testimony about what that's going to cost. And so ultimately, Judge, I would argue that charge, which is 20W5583, should be bound over as a misdemeanor criminal trespass. Now, once the prosecutor has a chance to speak to the victim of the property, and he's able to say, well, here are the pictures from the 15th, and here are the pictures from the 17th, and here's the pictures from the 19th, and we can see the difference in the damage between the 15th, 17th, and 19th, then the prosecutor can come back and visit us. But in the meantime, based on what you have in front of you today, the burglary should be dismissed, and the criminal damage to property in the second degree should be reduced to criminal trespass.
Ms. Henderson?
Judge, what we have here is a situation where the officer came, the defendant was inside, there was a...
Ms. Henderson, now, you went out for a moment.
Okay, for probable cause purposes, Judge, I think that the court can find that the purpose of the entry was to cause damage or commit a felony within the home. And as to the amount, Judge, we kind of have what we have. We don't have a specific timeline for that as to the criminal damage.
This is a probable cause hearing, and while probable cause is a low standard, there is still a standard that has to be met by the state. The court's going to find that the state as to 20W05582, burglary with intent to commit a felony therein, has not met that burden. Based on the testimony of the officer, there does not appear to be any indication or evidence to support that the damage that was caused within that property was at the hands of this defendant. So the court is going to dismiss 20W-05582 and 20W-05583, criminal damage to property in the second degree. The court's going to further agree with the defense and that the burden has not been met. However, there was an entry, so that will be reduced from criminal damage to property in the second degree to criminal trespass.
Yes, Your Honor.
Can we address the issue of bond?